Hello and welcome back to A Shark's Perspective. So this is one of those topics that's not studied a lot in school unless you're a lawyer. You don't find it in most lead gen strategy books. It won't come up generally with anyone running Google or Facebook ads. It's not part of your TV campaigns or empathy and leadership discussions. But if, like most businesses, there's a lot of pressure to grow, then understanding the legal complexity of customer contact preferences, especially as it relates to phone calls and texting, well, it's utterly important that you need to know more about the TCPA Act, a piece of legislation nearly 30 years old that can have a very heavy footprint on your best or worst practices. Eric Troutman is one of the country's prominent class action defense lawyers and is nationally recognized in Telephone Consumer Protection Act, TCPA, litigation and compliance, has served as lead defense counsel in more than 125 national TCPA class action litigations, and known as the Czar of TCPAWorld. And on this episode, we'll discuss TCPA, compliance, auto dialers, texting, personal liability, class action suits, Atticus Finch, cookie cutters, and a lot more. So let's tune in to the TCPA Czar with another Czar known as Shark the Great on this episode of A Shark's Perspective. Well, Eric, thank you so much for joining us today on A Shark's Perspective. If you would tell us a little bit about your background in law and your career to date.
Well, sure. I'm known as the world's greatest TCPA defense lawyer, the Czar of TCPAWorld.com. Little known fact, though, I'm actually a trial lawyer by background. I became a complex litigator somewhat by accident about 10 years ago when I was asked to take on my very first TCPA class action. And, of course, since then I've been lead counsel in, probably about 125 nationwide TCPA class actions since then. It's been a pretty fun ride, but TCPA is all we do all day, every day. We've got a big team that helps folks defend the lawsuits and stay out of trouble with compliance and advocacy to the FCC.
How do you get the nickname Czar?
A great question, actually. I had a partner at a previous law firm. And when I started there, he comes in and he says, "Man, Eric, you are remarkable in this space. I mean, you're not just like known as a TCPA litigator or like the defense counsel. Like you are the czar of the entire thing." And when he used the word, it was actually quite jarring. I remember I didn't like it at all, to be honest with you, and I kind of brushed it off.
Sure.
And it took a little while before I realized the visceral impact of the word was actually really very powerful. And so not long after I decided to adopt it, and it's been, everything else is history.
Yeah, I love it. So this is one of those topics I was telling a friend of mine not that long ago, that there simply isn't enough time dedicated and devoted in school to studying, especially in business. This is not one of those things, we spend so much time mentally and emotionally trying to figure out how to attract customers, how to get them to love your brand and everything else. But then you get emails from your legal department telling your sales and marketing and call center teams that there's something you need to fix or a problem or whatever. But explain in brief what TCPA is, how it's sort of graduated since, I guess this started in the early 90s, 91, I think. But where does the TCP Act sit as a piece of legislation today and with sort of how we've matured around it?
Sure. So lots there, right? The Telephone Consumer Protection Act was originally passed in 1991. It was originally designed to outlaw random and sequential number-generated phone calls, random fire telemarketing, basically, which was kind of the scourge of the day. And Congress acted to impose a $500 up to $1,500 per call exposure for those calls because they wanted to put these folks out of business. They wanted to absolutely make sure no one was using this technology. And it worked really well. Nobody uses random and sequential number-generated technology anymore, and they stopped doing that in the early 90s. But round about the year 2000, the FCC, who's tasked with enforcing the TCPA, started getting a whole bunch of complaints about so-called robocalls. And the robocalls that people were complaining about were not the random fire telemarketing calls that the TCPA covers. And so the FCC is kind of scratching its head because on the one hand, it's getting all these complaints about quote-unquote robocalls, and on the other hand, there's no statute on the books that prevents anything other than random fire dialers. And so what the FCC did, pretty momentous moment for all of us, is it decided to expand the TCPA by interpreting the ATDS definition to include predictive dialers and other dialers that call from a list of numbers automatically. This had just dire First Amendment consequences, but it also had the consequence of expanding the statute. And it's actually very interesting because most folks back in 2003 had no idea what the FCC had done.
Exactly.
And it took until, believe it or not, it took until 2011, 8 years later, before the first time any individual civil litigation ever referenced the 2003 FCC ruling. So from 1991 until 2011, the TCPA was believed to essentially only apply to random fire calls and to pre-recorded calls. But of course, after the FCC's ruling, things changed quite dramatically, and there was a series of FCC rulings that expanded the statute that led, of course, to the 2015 omnibus ruling, in which essentially every piece of software-enabled dialing device in the country was deemed an ATDS. That led to the D.C. Circuit Court of Appeal overturning the FCC's framework on ATDS, and the scope of the TCPA has, since March of 2018, been up in the air, with nobody really knowing what this massive restriction on free speech actually covers. So here we are not knowing if our speech is legal or not in the great United States of America, which is something that the Supreme Court will be looking at this term. So lots of fun issues here. The statute started narrow, got very, very, very expansive, and is now somewhere in between, and depending on what court of appeal you ask, could still be fairly broad or very narrow.
What do you think is helping determine whether or not it's fairly broad or fairly narrow? And I sort of have a follow-up question to that, in that I think a lot of this, and you referenced this back in the early 90s, late 80s, when a lot of these non-sequential numbers, right?
It's a random or sequential number generator. So imagine the old Homer Simpson auto dialer,
Exactly.
Right? 555-001, 555-002, that sort of thing.
So when you think about that, just the leap in technology we've made, one of the things that I think that the legislation, at least from my point of view, will never quite be able to keep up with the types of technologies that are able to just stay above the legislation, if you will, which is good and bad. I mean, the bad part is we end up with robocalls like what you do with abusive systems. But how do you sort of look at the legislation with the advancements in technology as well, and where somebody needs to sort of position themselves to be doing the right thing?
Well, so from a policy perspective, look, man, I don't know where to draw the line. I don't know what Congress should or shouldn't be regulating. But I will say that whatever they elect to regulate, the statute has to be clear. And the TCPA was never, ever, ever intended to be applied the way that it is. So there's no, it's not surprising that the statute is extremely vague and no one knows what it applies to, right? And it's not surprising that the Supreme Court is looking at the statute because it affects free speech, because nobody knows what it applies to and it's content specific. The statute as it is currently drafted is a problem, right? How do you fix it? I don't pretend to be a lawmaker. I don't have all the policy answers. I know that however you fix it, the lines have to be clear so that folks that are trying to comply with the law can comply with the law. And you asked something a while ago, which is, what's determining whether or not the statute is broadly or narrowly applied. And unfortunately, it's very kind of ad hoc. The courts that are looking at the statute are interpreting its language, and some courts are saying the language is very vague, and we're going to apply what we think congressional intent was. And to kind of your point, we're going to keep updating the statute, right? Kind of like it's a living, breathing statute to apply to advances in technology. And other courts are looking at it and saying either, no, this thing is crystal clear. It applies just to random and sequential number generation, or it is saying, look, this thing is ambiguous, but we're going to read it narrowly because we've got free speech concerns. And oh, by the way, if Congress wants to do something more, it can sit down with a pen and paper and write a new law and then vote on the new law, right? Which is the way it's supposed to work in this country.
Yeah, well, I mean, it's amazing to me that a almost nearly 30-year-old piece of legislation, that we're so far behind in updating that law and writing a new piece of law. And it's kind of the same thing for me working in the space that I work in today, where when you think of somebody like Elizabeth Warren, who gets behind championing what we're going to do with social media or not, good luck. I mean, they're not even, if you think of things that really impact business, they're never going to be able to keep up with social media, just like this law hasn't, at least in my opinion, kept up with the advancements in technology. And fairly enough, I don't know that you're ever going to get a body of hundreds of folks in DC to ever agree on it. But if you kind of dial back, what has the TCPA done, in your opinion, to help clean up the industry in the basically 30-year period?
Well, the TCPA is kind of a success story on the one hand and a complete and utter failure on the other, depending on how you look at it, right? So if you look at it through the lens of the TCPA being used to stop scam robocalls, it is a complete and utter failure, because what the TCPA does is it allows folks to file private lawsuits. But if you think about who the plaintiffs bar, these lawyers that are bringing these lawsuits, these class actions, who they're suing, they're not suing scammers. They're not suing, the overseas bad guys. They're suing legitimate American businesses with green money and real American bank accounts. And American businesses almost exclusively are not making these calls. They're making legal phone calls, or at least they're trying to make legal phone calls. That is to say, they're at least not making scam phone calls. They're trying to reach their customers at phone numbers, by and large, that were provided by their customers. And so most of these lawsuits are targeting, good to either truly good actors or actors that are trying to be good, but just kind of caught up in a very difficult compliance landscape. And the lawsuits are kind of, in my opinion, some shade of bogus. And now, on the other hand, the TCPA is good because it does force people to honor contact preferences. And that's just good business anyway. And we think about kind of in the lead space, I always tell folks that, compliant leads are going to convert better, right? These are folks that are going to have had actually chosen to opt in, actually accepted written consent because they actually want the information that is going to be sold to them, or that is to say, they want information about the product that is going to be sold to them. Mm-hmm. If you're in the servicing space, which is a little different, I know, than your listeners, but many of my clients are servicers, and I tell them, look, if you want the customer to actually answer your phone call or respond to your text, you should probably honor whatever contact preference they prefer. And if they want to be texted, then text them. If they want to be called, then call them, and don't do something they don't want. And that's just good business sense. It keeps customers happy. And yeah, the TCPA kind of provides teeth to that. So from the one, from the one hand, it's a good statute in the sense that it does force folks to kind of pay attention to contact preferences. But, given how much completely frivolous and abusive litigation this thing has created, and the millions and millions and millions and millions of dollars in legal expense and settlements that it has kind of unleashed, it's challenging to say that the TCPA is a success story, especially when you look at the scourge of robocalls from the illegal actors we continue to see. In my opinion, I think Congress could do a heck of a lot better, just a heck of a lot better, both in defining the statute in a way that folks can actually understand what technology is being covered, but also you get rid of the private right of action, or you narrow it, give them a year on the statute instead of 4 years, get rid of the $500 per call minimum statutory violation damage. It's just much, much, much too high. And you could still get the same positive effect without all this these terrible, just very predatory lawsuits with lawyers getting millions and millions of dollars. It's just bad. It's just ugly out there.
Are you sure you want to make that controversial of a statement that Congress could do better? I mean, you're going to make no one on the planet offended. Right? Yeah. But anyway, jumping back, did any of the verticals as a whole dramatically improve after the legislation sort of went into act over the last 20 years?
Yeah. So back in 2000, and I look at this as there's been waves of TCPA lawsuits and compliance. So the first wave kind of came in 2008, 2009, 2010, when folks started realizing that the TCPA might be actionable in federal court. Little side note, the TCPA was actually never even supposed to allow direct private causes of action. It was supposed to actually just enable state court lawsuits under state law, but there was kind of federalist concerns because many phone calls were being made across state lines. There was questions as to whether or not states could regulate these interstate phone calls. So the TCPA was just supposed to allow lawsuits in the state courts. So as time kind of went on and folks started realizing, hey, we can file these in federal court, as the Supreme Court confirmed in a 2012 decision called MIMS, litigation skyrocketed. And the first kind of batch of settlements came. And I mean, it was the wild, wild west. I remember in 2008, major companies that you've heard of, trust me, didn't have any kind of TCPA policies because they thought this stuff only applied to telemarketing, or they thought it only applied to random fire dialers. And so there's this big eye-opening in 2008, 2009, and folks, settled a whole bunch of these cases. But it did improve right there. The communication interactions between major companies and their customers. It was kind of the first, awakening that, hey, we need to take contact preference seriously. We can't just call people as many times as we want. We can't just call them using whatever technology we want on whatever number. We have to kind of hear out our customer and be responsive to their needs and desires. And that's great. I mean, we're dealing with the age of millennials and now Generation Z, and everyone's a special snowflake, and they want their preferences met. And the TCPA kind of enables that, right? Sure. And that's not a bad thing necessarily. Again, it's a brave new world for businesses out there, and they need to understand that this is the expectation, and the TCPA just kind of accelerated that. And you kind of go through the arc of time, and you've got, in 2015, of course, there was revisions by the FCC that expanded the statute further, clarified the ability to revoke consent, modify those contact preferences, more or less in real time. And again, the businesses kind of had to scramble to catch up to the new articulation of what the law allegedly had always been. That led to a bunch of new settlements, but it also led to further engagement with customers. And now, of course, you've got most folks are developing, if they don't already have them, kind of landing pages with demographic information where consumers can kind of opt in and opt out on a phone number or account level basis in terms of what contacts they want and what contacts they don't. And all of this, seemingly very consumer-friendly stuff, seemingly just kind of an experience enhancer, is actually driven by fear of litigation. So, from a certain perspective, again, not to pat the TCPA on the back too much because it does not deserve much praise, but it did enable, these sorts of enhancements that we're seeing around customer experience on contact preferences.
Well, I was asking in particular what verticals had you thought done better since, enactment of legislation. But I'm going to save that because really what I'd like to know, because I also have some thoughts on what I'm going to guess it's going to be. I'm more interested in knowing what are the worst offenders that you still see today? And I don't mean companies as a whole, but what industries are you seeing just a massive amount of lawsuits with bad actors in this space? Is it mortgage, banking, finance, home services? What do you see, or is it just across the board?
Well, I don't see, I'll be honest with you. Folks come into my office and they say, hey, Eric, I've got an illegal business model. I just kick them out. So, my clients, by and large, are all companies that are trying to be compliant. And so, what I see is a landscape of folks that are either good actors or near good actors, folks that if they have a fault, it's that they're trying to be a little more, aggressive, I would say, and less risk averse around the margins, like around the extreme margins. But everybody, in my view, everybody's at least trying these days to comply with the statute, and that's a good thing. Where do you see kind of folks being a little bit more aggressive maybe than they should? Well, I mean, anytime you're dealing with marketing, the pressures here are extraordinary. The pressures are extraordinary, and I think that's true across all verticals. So am I going to pick on, the folks selling mortgages over the folks selling insurance over the folks, selling, the EDU folks, versus alarm companies? I mean, I can't tell you anything other than everybody seems to be awakening to the reality of the TCPA simultaneously. And within each vertical, there are going to be groups that have more risk aversity and those that are going to be more aggressive. And those that are more aggressive are they are running a risk. And I will tell you, and this isn't going to surprise you, everybody out there now, it's no longer the case that you can plead ignorance. That was the case 10 years
Absolutely.
ago. You could say, honestly, I had no idea, right? Now, nowadays, you can't plead ignorance. If you hire somebody other than Eric Troutman, maybe you can plead, ineffective counsel. But in seriousness, no one can say that they don't know about the TCPA. So
Agreed.
now it's a question of what risks are you choosing to take versus what risks could you have avoided, and in the name of profit. And to me, again, circling back to something I said earlier, the legal leads are going to convert better anyway. If you're just looking for volume and you're going to take, whatever, God knows where it came from, and God knows if it's got a journey or if it's lawful lead.
Right.
Good luck with that, because you're probably not going to convert on it anyway. And instead, you're going to take on a risk now, $500 for that phone call. And chances are, even if you did convert, you weren't going to make $500 off that phone call anyway. So to me, there's very, very little business sense to adopting a model that absorbs undue TCPA risk. That being said, it's the same. I see it all the time. I sit down with one of my clients, and we have a conversation, and they're like, yeah, you're right. A big come to Jesus moment. And then, 3 weeks, a month later, it's like, well, what's going on? Well, so-and-so down the street was using a new call center, and they seem to be doing great. So we're going to try it too. And it's like, okay, right? It's just that the pressures, are extraordinary. These things move very, very quickly, as you know. Some of these verticals, you got to get that phone call out within 2 seconds of the lead if you're gonna convert, and that's just the way it is. And so you got to build in and operationalize your TCPA compliance, which again most folks have done. And these days it's just an issue of kind of where are you going to draw those lines. But the last thing I'll say on the topic is no one is safe.
Agreed.
Absolutely no one is safe. You do not want to be low hanging fruit.
Well, that makes me feel a lot better, because what I was going to guess was it was across the board, because everybody I talk to in every industry feels the same amount of heavy pressure. And that's causing them to, when they make a mistake, it's not industry specific or anything else. I just wonder if sometimes I'm missing reading the tea leaves right as well. But, that's the pressures are everywhere. So even in a good economy, but, I know you work on helping build out a lot of TCPA compliant processes, policies, and systems. And a lot of larger companies have attorneys on staff, or they have somebody on retainer who works at this. But what do you see a lot of that? I'm going to kind of label it in-house or typical outsourced counsel missing? Where do they come to you to help defend? What are some of the things that you typically see somebody forgetting to dot an I or cross a T to make something happen?
Well, there's enormous complexity here, enormous. And so what folks need to understand is the biggest companies on the planet turn to us because they've got in-house specialists, right? They've got literally a team inside of that company that does nothing but TCPA, and they will still pick up the phone and call us for a couple of reasons. One, because I've got more experience in this stuff than anybody on the planet, and I can say that without question. And so that is a helpful resource. But two, because the risk is so extraordinary, and these days, if you are an in-house compliance person, you can actually be held personally liable for a TCPA issue if you miss it. But they want cover, right? They want cover. And so, there's not too many people out there that can say they've built, these TCPA processes for the largest enterprises in the country, and help to take, folks with, you can imagine, 10, 15 different product lines, and they're all working separately, and get them to all work together under an enterprise umbrella. So we serve as a chief architect. We can help project manage, and we can help kind of look over everyone's shoulder. But to answer the question that you were saying, like, what are people missing? People miss a lot because there's so many little things. And, I'm scared to say too much because I don't want to give any plaintiffs lawyers that might be listening, too much fodder. But, the biggest thing I've seen recently is people waking up to the awareness that even if you're not using, automated technology, if you're making telemarketing calls, you got to have an internal do not call list, and you've got to have the written policies and procedures. And, this stuff matters. You see a lot of mistakes with people thinking B2B calls are somehow going to be exempt from the TCPA. You see a lot of mistakes with people using the same system for their manual and their automated calls. or folks trying to separate the two, but just not doing a good enough job because there's still a
that's
good and risky level of integration
100%.
between the two. So I mean, but then you see things, just basic things too, like you don't even have TCPA policies. Like, what are you guys doing? You know?
Yeah.
So in any event, yeah, this is kind of what we do. We've got we've got a huge litigation arm, and we've got the compliance arm, and we can conduct audits. We go in, we make sure that you're buttoned up, kind of soup to nuts. But again, we help smaller companies, we help medium companies, but our bread and butter, believe it or not, are actually the larger companies that actually have their own in-house lawyers that do this stuff, but they still come to us for that protection, that additional layer of security.
Well, it amazes me over and over with a lot of big companies that I've consulted with over the years, who, as big and sophisticated as they are with technology, still partition out data to different departments and then don't know, that somebody could be on a do not call list from one department, internal department, to another, and then somebody randomly calls and it becomes a problem. And it's shocking how sophisticated they think they are with their data, and yet they don't even let their internal teams know when somebody shouldn't or should not be called. It just amazes me. But dive a little bit deeper, because I've heard you talk about this before, about the personal liability with TCPA compliance and those violations. How far in does that extend if you are a violator within a company? I mean, does that extend to the person maybe just making a telemarketing call if they're at a call center, or is that the legal team? What's the sort of layout with that to understand where you're personally liable?
So the contours are still not clear.
Yeah.
And so let me just start addressing this by saying the TCPA is just powerfully unfair. It's unfair on a number of levels. We've already talked about the fact that it's completely vague, and yet it impacts free speech. And so you don't even know if your speech is legal or not to begin with, which is just an abomination. And then you compound that by thinking that the TCPA is unlike 99% of the laws out there, where if you do something illegal while you're working with your employer because you thought it was legal, you thought it was fine, and your employer told you to do it, and so it's just what you're doing, you're not liable for that individually, right? You are serving as a corporate employee. The employer might be liable, the company might be liable, but you're not liable. If an officer or director of Chevron says, dump a bunch of oil in the water, and they don't do that, I presume, but if they did, right, Chevron wouldn't be liable for dumping a bunch of oil in the water. The individual that directed or oversaw, that action is not going to be personally liable for that, except maybe the shareholders. But you look at the TCPA, and because of the way the statute is worded, it has been applied. Unfortunately, the majority position is that you can be held personally liable if you, quote, personally participate in the violation. And I should note there's a minority position that I think is correct, that holds that the TCPA is really no different than any other statute, and you shouldn't be held personally liable if you acted within the scope of your employment. Mm-hmm. But focusing on the majority position, which says that you can be held liable, there's no, the exact outline here, the exact contours have not yet been completely and firmly established. We know, for instance, if you work at a call center, you should get hazard pay these days, because if you are placing a call, you can be personally liable for that call. If you send a fax, you can be personally liable for that fax, even if that's just your job. If you are working at a call center and you're the person that puts together the campaigns, right? You're the one that is identifying what phone numbers, what lists to call, and how they should be called, and you are feeding those campaigns. I think you're a campaign manager, or certainly, somebody that is in the marketing team and putting together campaign parameters. You are, in all likelihood, going to be somebody that might be deemed to be personally participating if those phone calls end up being illegal. If you are a compliance officer and you are trying to comply with the TCPA, but you misread the statute, misapply the statute, don't understand what express written consent is and what the requirements are, and okay a program that, for instance, doesn't use the right language, or doesn't capture the right kind of consent, or doesn't require the proper sort of signature, then you too can be personally sued for failing to assure compliance with the TCPA. Now, those are all examples of cases that we've seen. We've also seen CEOs get named and other kind of marketing executives. What we have not yet seen, but I cannot tell you that it is not within the parameters, I'm just telling you I haven't seen it yet, is anybody that's a legal counsel, for instance, like a general counsel or an in-house counsel. There seems to be privilege issues there, so it doesn't seem like those individuals could be named. But, I mean, at this point, who knows? So what I tell folks is, again, if you're making this decision and you can be deemed as personally participating, that's one thing. But if you've got outside counsel and outside counsel is kind of directing the maneuvers, then it seems to me maybe you're not personally participating anymore. And even there, I have to say maybe, because although I feel pretty confident about it, that too is untested right now. So unfortunately, this is murky, right? The personal liability is probably the scariest thing going out there, and yet it is also the murkiest because it's still developing. And of course, I think it's bush league, just utterly bush league. If you're suing a company and then you add one of their executives or one of these low level call center employees, I mean, it's just, to me, it's just despicable. It smells like extortion. You're just doing it to leverage and try to get a settlement out of these folks, and you're just adding people individually that don't have deep pockets. I mean, to me, there's no good reason for it. And you'd hope that the courts are going to shut this stuff down. But again, it's developing, and you got to be careful. So, what I always tell folks is, look, if you're a compliance lawyer, reach out to us. Let us help to protect you. As opposed to trying to go it alone, and make sure you've got insurance coverage,
Exactly.
and that's it's a very serious issue.
Well, when the TCPA was enacted back in '91, we were all using, for the most part, landline phones or a giant brick mobile phone, but I don't think anybody was making calls then for marketing as a whole. But when I think about this specifically with technology, I think that there's no limit of where we can go with technology. And when this all started back with just landline phones back in '91, I'm kind of curious how you help guide clients now keep those processes in place when that they're going to purchase and enable more technology going forward that could cause them to get into trouble.
Yeah, so the TCPA, again, is worded very narrowly, and it is not an all-purpose catch-all for all outreach technology. Yeah. It was never intended to be that. But I agree with you, right, that there are some courts, and the FCC has shown a tendency to treat the spongy language expansively and try to use it, even though it wasn't intended, use it to cover any sort of outreach technology. And so you've got court decisions out there that apply the TCPA to text messages. I think that at this point is pretty non-controversial. A text is a call for the TCPA. It's been applied to ringless voicemails. It's even been applied to email,
exactly.
Believe it or not. When the email is being sent to a wireless carrier's email address, like a phone number at VerizonWireless.com, for instance. But to me, the next kind of big frontier for this is the alerts and push notifications that are being sent through apps. And so to me, and I always tell folks this, right? You want to get customers into your ecosystem. You want to get them to go to your website, to accept your disclosures, and ultimately, you want to download the apps. You want them literally with an app so that you can communicate with them through notifications and alerts that they can set up on their apps, so there's no question that there's consent. And apps, unlike text messaging, you're not using phone numbers to transmit messages through a push notification to an app. You're using individual tokens that go to that handset or go to that app that was downloaded. So the TCPA, which applies to calls made to phone numbers, probably does not apply to push notifications to apps. So it's a very fertile ground for folks that want to stay in communication with their existing customers and provide good service or good nurture and growth campaigns to use an app. But you are correct that it's a challenging time for everybody out there, because technology continues to run, and as technology runs, we are looking back now at these ancient laws.
Exactly.
And again, it is the most frustrating part is that you don't even know for sure whether or not that ancient law is going to be read to try to keep up with you or not, right? So kind of question one is the court even going to try to expand the statute to keep up with existing technology? And you don't even know the answer to that question. And then the answer to the second question is, if the court is going to try to expand the statute in some way, is the expansion going to cover you, or have you somehow outran that expansion because your technology doesn't quite meet whatever expansive definition it is that the court is going to apply? So there's kind of like double uncertainty, which is, as you can imagine, really pretty intolerable for business. And I do feel bad for them. And we do everything we can to defend them and keep them compliant, but it is very challenging.
So you personally, as an attorney, you've been involved with, what, 70 plus class action suits now?
Oh, that's dated. I'm well over 100. I think I'm estimating probably about 125 that I've been lead counsel on in the class actions, and then over 1,000 individual suits as well.
If you had to think just through this, I mean, I don't aspire by any stretch to be an attorney, but what is it like to be part of a class action lawsuit like that and win, let alone be one that you feel like is a good cause, that people in general help support? I mean, obviously you have an adversary on the other side, but what is it like to win one of those?
Oh man, it's sweet. It's sweet. When that ruling comes out saying that certification has been denied, when that dispositive motion comes out, I mean, it is no different than when you hit the game-winning shot, right, with time running down to beat the buzzer in March. I mean, we are hooting and hollering, we are high-fiving. Champagne is absolutely getting broken into, and we're done for the day, man. We walk out. I don't care if it's noon, right? It's like, hold my calls. We're out of here. It is huge, and I always say, and I could be wrong, but to me, this is a no-failure profession. I have to this day never lost a certification ruling. I truly believe, whether it's true or not, that you can't survive in this space losing those things. They're too big, and everyone's going to know about it, and the market is too small. And so we've kind of built a reputation for handling the biggest stuff out there. Multi-billion-dollar federal court class actions is all we do day in, day out. But the stakes are incredibly high, and there is an incredibly high bar for the work product that we have to turn out, because success. I've got a big sign in my office that says failure is not an option. It literally is not an option, and you have to view it that way, because every single case we have is a bet the company case. Every single one, and every single one, in my opinion, has the potential to kind of end your practice, right? You can't live long in this industry losing big cases. You just can't.
So you've done 125 or so. How long does it typically take a case? I mean, the law is not a fast process, but how long does it typically take a case from the moment, say, to start to where you get a verdict, an adjudication on it? I mean, what's the average tenure for that entire process?
Oh, no, so they vary remarkably. I mean, we can get cases in where we can establish a quick defense. Many of the folks on the other side I've been litigating with for years and years. They come on my podcast, TCPAWorld.com. By the way, the podcast is the Unprecedented Podcast. You should check it out. And they come on our podcast, and they're buddies and pals, and we can get stuff done real quick. And I mean, like within days. And then there's other cases where you have to kind of beat them up a little bit, right? You have to soften them up. You file some motions. You let them know it's going to be a dogfight. You punch them in the nose a couple of times. And they back off, and you settle the case individually. And then there's other cases where you get deep into discovery, and you're battling. One of the things that I think sets us apart in our defense strategy from other firms is we are very aggressive in discovery. We file protective order motions. We seek motions to compel. We pursue any angle we can against a class representative who maybe shouldn't be representing that class. And we've been very effective at demonstrating burden, demonstrating a lack of proportionality when plaintiffs are seeking really expansive documents, which they always do in these cases. And maybe you have to win a couple discovery battles before you can get the case resolved. And then other cases, you have to go all the way. You have to go all the way to certification. And as I mentioned, we've never lost certification. You don't want to be losing that. To this date, there have been 6 trials of certified class actions in the TCPA space in history. 5 of them have gone in favor of the plaintiff. Only one defense counsel won the case, but they ended up actually not winning the case because even though they successfully convinced the judge to take out plaintiff's primary evidence regarding the fax recipients, the court nonetheless gave notice to the class and allowed the class members directly to make claims and create a judgment based on the class's own claims of having received the faxes at issue, which should never have happened. But my point is, nobody has ever walked away from a certified TCPA class action unscathed. Nobody. And the verdicts in this space have been over $900 million. There was another one for $267 million. Some have been have been over $1 billion, although those have been reduced on constitutional grounds. So it's just brutal out there.
I read on your firm's website that in your spare time you lead defense teams representing banks and other financial services companies in consumer finance litigation matters. Have you ever thought about maybe trying something like golf? I hear yoga's relaxing.
It's funny. All I do, I've got 3 kids, right? And if I'm not working, I'm playing ball with the boys. That's it. That's all I got. It won't surprise any of my listeners or any of my readers to hear me say I have zero social life. I don't have a hobby. It is just my career and my kids. That's it.
Yeah,
that's all I've got.
And family first. There you go.
Yeah.
All right, Eric, you're near the beaches of LA and the cold waters, but you're talking to a nickname shark. So I've got to ask, what is your favorite kind of shark and why?
No, it's interesting because you didn't tell me in the lead up that you were going to ask me this question. But as I just mentioned, I've got these 3 kids and they're actually really into sharks. Overruled. I can continue. Yeah. So I've been reading actually to my kids about sharks, and I do actually have a favorite shark, and it's kind of dark, I guess, because the shark is the cookie cutter shark. And the cookie cutter shark is a deep water shark, and it's got this weird kind of like round jaw. It's actually a horrible little shark because it doesn't eat its prey; it just takes a bite out of its prey, wriggles its body around, and like takes a circular chunk of flesh out of its prey, and then like swims away. And they're pretty small. They're not that big. And so the prey, for the most part, will live, although sometimes it doesn't. But the shark just takes a bite out of you, basically walks away, and that's it. The shark is happy because it's eaten a stomach full of food, and it just moves on. And I just thought, what a bizarre creature to just kind of take a bite out of you and just kind of move on with your life. I guess that's kind of like how the plaintiff's lawyers like to live. They don't kill you all the way. You can shear a sheep many times, and if you're a cookie cutter shark, you can take a hunk of flesh and move on to your next victim, I guess.
Yeah, no, I have seen one before. They're also nicknamed the cigar shark, which is weird, but it's a better name, for how they make those bites. But anyway, well, Eric, it's that special time in the show. Are you ready for the 5 most interesting and important questions you're going to be asked today?
Sure, let's go.
All right, number 1, Gregory Peck in To Kill a Mockingbird or Joe Pesci in My Cousin Vinny? Good legal movie question.
Gregory Peck.
Thank you. Number 2, a czar question for the czar himself. Ivan the Terrible or Catherine the Great?
Ivan the Terrible.
Number 3, which one will have better TV commercials in 2020, in your opinion? Presidential candidate Mike Bloomberg, which is on like every 30 seconds, he's got a new one, or your arch nemesis, Morgan & Morgan?
Ooh, well, if you're talking volume, it's definitely going to be Morgan & Morgan.
Exactly.
If you're talking quality, some of those Morgan & Morgan commercials are pretty compelling. When Tav Gomez starts speaking Spanish, hawking ficra, I don't know. That's pretty strong stuff. Yeah. So I'm going to have to give the nod to the world's biggest plaintiff's law firm down there in Florida.
I see those commercials. It's the only ones that I see more than Bloomberg. I've used it in several presentations. But anyway, number 4, preferred technology as it applies to TCPA, phone or text?
Well, both will get you in trouble, and text will get you in more trouble in all likelihood. But texts are also the way that you want to communicate these days with people. So I think text is a preferred technology, but just recognize that it is covered by the statute, and you got to be very careful with it because it leaves a residue on their phone, and folks love taking pictures of those texts and sticking them in complaints if they didn't want to receive it.
Great explanation. Number 5, and the most important question that you're going to be asked today is biscuits or cornbread?
Oh, that's actually tough. I love both biscuits and cornbread. I'm going to have to go with cornbread, though. Cornbread is very good.
Good man. All right. So, Eric, where can people find out more about you, keep up with what you're doing, follow your writings, legal opinions, the podcast, and more?
So TCPAWorld.com is recognized as one of the best breaking news blogs in the country. It is, in my opinion, the single best legal resource there is for the TCPA. We break down every development as it happens every single day. We also have a hard-hitting and awesome little podcast of our own called the Unprecedented Podcast, also available on TCPAWorld.com. Hundreds and hundreds of articles up there, lots of breakdown, very easy to find us. Just go ahead and Google my name or TCPAWorld.com, and you'll find it no problem.
Perfect. Eric, thank you so much for being with us today on A Shark's Perspective.
Yeah, thanks for having me. Good time. Take care.
So there was my conversation with Eric Troutman, one of the country's prominent class action defense lawyers, and is nationally recognized in Telephone Consumer Protection Act, litigation, and compliance. Has served as lead defense counsel in more than 125 national TCPA class action litigations, and known as the Czar of TCPAWorld. Let's take a look at 3 key takeaways from my conversation with him. First, so what should we do or not do regarding the TCPA Act? Well, I'll oversimplify it, and I'm neither a lawyer nor a lawmaker. However, as he said, Congress put together a vague piece of legislation. There's a lot of good in it for us, the consumer, but it's also created a lot of chaos for businesses over the last 30 years. It's created opportunities for people to skirt around the system, and that allows for a lot of bad actors to do the wrong thing, as well as some of those who create frivolous lawsuits for those that don't. Kind of reminds me of some other pieces of legislation out there. But as he said, you cannot plead ignorant to this anymore. And if you simply think that customers do not want to call you, they just want to text, then texting can get you in just as much trouble, if not more. I'll at least say this, especially to any small business that's growing. You'll spend more time on something like this than you thought you would. We spend so much time thinking about leads and getting new customers and loving them and them loving us back and likes and shares and all of that. But please understand that just because you didn't design a marketing campaign, for example, around calling someone in a call center might break the rules without bad intentions, or some third party that sent you a lead could have done the wrong thing to acquire that lead. Should you be scared? No. But aware? Absolutely. And more aware than just passing it off to your legal to give you some guidelines. Everybody needs to know more about this. I've seen this happen to so many businesses I've worked for or either consulted with, and it's almost always something stupid that gets them into trouble. So be aware, be more vigilant than you've been before. Second, we shouldn't need to preach more about customer experience, especially in regards to unwanted phone calls, text, and the like. But if you don't want to hear from attorneys, then you should, as Eric said, honor your customers' contact preferences. And I will also remind you then to align every system and set of data that you have so that someone in another department who doesn't share the same data set of a consumer who wanted to be on a do not call list doesn't get you into a legal bind for a dumb mistake across siloed teams and disparate data sets. Third, the pressures in marketing are extraordinary, so it's often that someone picks up the phone and does the wrong thing by accident. Love it when he said the question is, what risk are you choosing to take versus what risk could you have avoided in the name of profit? Bad practices and junk leads can get you into trouble, and you can be held personally liable and named in a lawsuit. Should you be worried if you're in a call center? Not necessarily unless the wrong intent is there and can be proven, but the idea that there is risk is just cray-cray. Especially when you think about how much you push your customers away, and if the company you work for isn't doing the right thing with a customer's preferences. So before picking up the phone, at least ask the question, even if it's only to yourself, did you acquire the right to call someone in the right legal and compliant manner? That may seem like the equivalent of just taking, an aspirin to fight off some major sickness, but it's not only a legal concern, it's also a CX one. Be clear on your disclosures and look at your technology and automation too. The capabilities in technology will far outpace how quickly the standards are set by those laws. And it will far outpace, sadly, how well most businesses truly listen to customers. Got a question? Send me an email to kenneth@asharksperspective.com. Thank you again for the privilege of your time. And remember, Shakespeare said that the first thing we do is kill all the lawyers. Just make sure that you're compliant in case you have to call them first. So join us on the next episode of A Shark's Perspective.